attention. God save the United States and this honorable court. This honorable court is now in session. Please be seated and come to order.
Good afternoon, everybody, and welcome to the District of Columbia Court of Appeals. We have on this afternoon's calendar one case, which is an appeal from an emergency appeal from a detention order. It is case number 19-CO-1091, William D'Angelo Edwards versus United States. Whenever you're ready.
Afternoon. May it please the court, Pierce.
Did I say good morning?
May it please the court, Pierce Sewin on behalf of William Edwards, and if I could reserve 2 minutes for rebuttal. So we touched on this in our pleadings, and for the trial court's detention order to be legal and to be proper, 2 things have to be true. First is that preventative detention under DC Code 23-1322 has to be found to apply to SPA civil commitment proceedings. The second is that the tolling of the clocks in 1322 also has to be found to apply to SPA civil commitment proceedings. Now, where neither of those things are true, this court should reverse the trial court's detention.
Can you tell me what's the practical difference between those two arguments? That the 1322 doesn't apply at all, and that if you look at the 4 tolling provisions, none of those applies. If as far as a remedy goes, and just as far as which argument you're most pushing, what's the distinction there?
So it's, from a practical perspective, for Mr. Edwards' case, there really isn't one. I mean, we went back and we kind of looked at the clock calculation, and at this point, were 1322 to apply, but the tolling not, we would be past the 100 days, and so the remedy, I think, still was the same. The court would have to, would reverse, and then Mr. Edwards would have to be released. To a certain degree, there's not really that much of a distinction between the two, because ultimately 1322 kind of as a structural whole just doesn't apply. And
can I ask you, do you also think 1321 doesn't apply once a Sexual Psychopath Act statement has been submitted?
in terms of the setting of conditions of release, I think that is slightly different because we're not dealing with a liberty interest.
Right. It may or may not be different. Is your answer different, or is your answer the same, even though the situation is somewhat different?
So I think as a matter of law, given kind of the timing of how the law developed, the provisions in 1321 wouldn't apply.
Would not apply.
Would not, but.
So just to make sure I understand that concretely, if a defendant is on release and there's a stay-away order, let's say, and the United States chooses, or the trial court sua sponte submits a Sexual Psychopath Act statement, you would say the operation of that would be to lift all conditions of release, including the stay-away?
No, sorry. So I don't think I was clear about that. I think the critical distinction here is detention and not. And this, I think the distinction that is drawn there is centered around the SPA and what was in effect and what Congress would have intended when the SPA was created in 1948. In 1948, the requirement was that criminal defendants charged with non-capital offenses be released on bail. The similar requirement was that the trial court did have the authority to impose something like a stay-away, conditions of release to regulate certain things. And those things, I think, would remain in place.
Well, your broadest conceptual argument, I thought, was, look, once there is a Sexual Psychopath Act statement submitted, the case isn't on a criminal track anymore, and provisions like detention that are focused on the criminal process are just not applicable. And the SPA has its own procedures, such as they are, and they are what will govern. And if that's the right conceptual way of looking at it, it seems like that would have applied equally well to 1321. If your basic theoretical point is just we're no longer on a criminal track, so criminal provisions like 1322 are inapplicable. It seemed like the logic of that would have taken you to 1321 as well.
So if I can answer like this, so the theoretical point is more so confined to 1322 because the difference more so is the preventative detention issue. Again, so talking about kind of how the SPA was created in 1948, preventative detention obviously at that point didn't exist. It wasn't created until 1970. And when it was created, it's really kind of a sea change in how the courts are going to deal with criminal defendants coming before the system. The intention, I believe, of Congress in 1948 would have been to allow certain things to proceed essentially undisturbed that existed in that system at that time. And so what we're trying to get at is this word stay. Can the word stay be essentially extended and warped to a certain degree to get to something like no bond, preventative detention, something that didn't exist for years? And really there's three reasons why the government's asking the word stay to do really too much there. And so the first is that the word stay as kind of contemplated in the SBA itself just can't be seen to cover pretrial detention. The second is this kind of historical basis, the 1948 backdrop where everybody is.
Well, what is it? I'm not quite sure I understand what you mean when you say cover pretrial detention. If there's a criminal process in place, and there are orders in the criminal case, and then an SPA statement is filed and it stays the criminal proceeding, are you suggesting that you have to have like some sort of case-by-case inquiry into what parts of, what prior orders in the criminal proceeding are stayed under the SPA and which aren't, and the way to do that is to try to figure out what the what procedures were at the time of the SPA, and the things that would be stayed would be those that would have been contemplated by the legislature in 1948, or what? I'm not quite sure I see the mode of reasoning.
Sure, so I don't think we need to get that granular. And when we look at the SPA itself, the word stay isn't defined, but it's a stay of criminal proceedings. And the words criminal proceeding, that concept is in fact defined. In 223803, the definitional section, criminal proceeding is described as, is defined as the stages of a criminal proceeding. And as far as preventative detention goes, it's not the, I would say, correct understanding to see a preventative detention order as a stage of a criminal proceeding, right? The stay there is, I think, meant to operate on preserving the viability of the charging instruments.
So what do you think would have happened if, imagine soon after the passage of the SPA in 1948, or imagine you're thinking as a legislator in 1948, and a defendant is charged with a capital offense that permitted detention back in 1948. Is it your sense that the legislature would have intended that as soon as an SPA statement was filed, that release would be required because whatever detention was existing for capital cases wouldn't be subject to stay under the SPA, or that somehow it's just not applicable? How would that have worked in a case like that?
I guess, were there to be detention authority, that may be the context where it would exist, but that would would be a kind of a factual impossibility, because capital defendants charged with capital offenses would not fall into the SPA. They wouldn't be eligible for the SPA proceedings based on the terms of the SPA itself.
You mean as of 1948, it was impossible for a defendant to be in a capital proceeding and the subject of an SPA statement?
Yes. And the SPA goes out of its way to remove the quote-unquote most serious offenses from its application. The SPA specifically doesn't apply to people who are charged with first-degree sex abuse, second-degree sex abuse, or with assault with intent to commit.
What about murder? What about first-degree murder, for example?
I don't think we generally conceive of first-degree murder as a sex offense that would trigger the operation of the SPA.
Well, I didn't realize. I didn't think the SPA was required certain kinds of offenses to be the pending criminal charge. It obviously requires proof of sexual psychopathology, whatever that means. But are you saying that as a matter, your understanding is that as a matter of law, it would have just been an impossible scenario in 1948 or soon after 1948 for someone who was subject to detention because facing a capital charge to be the subject of a Sexual Psychopath Act written statement?
Yes, that is my contention. I think that was the underlying intent of Congress also, right, to remove the most serious offenses. And also, the statute was created as, I think, the legislative history makes clear, and kind of the courts have read it to be this humanitarian alternative, so to speak. I think it's really a far cry to say that, well, that Congress had also contemplated that to apply to capital offenses like murder.
What do we know about how long these proceedings take? And I feel like we have kind of a blank, we don't have a lot of information to inform our decision in that regard. And do you have a sense of how common these proceedings are, and what are you expecting this to mean for your client?
So from a practical perspective, our understanding is that this really is fairly recently resurrected by the U.S. Attorney's Office. There aren't very many of these. As far as I know, there's the Tilley case that's pending before this court as well. There's this one, and there's one other person in the trial court right now who has had an SPA statement filed against him. These things take, as far as Mr. Edwards' case goes, from a factual matter, these things take a long time. The SPA requires the appointing of 2 psychiatrists who can do this examination, and then it contemplates hearings down the line. As far as for Mr. Edwards, the 2 psychiatrists have not yet been appointed, much less having, say, gone and examined Mr. Edwards. And kind of in the backdrop of this is that it's, anecdotally speaking, what I can tell the court is that it's difficult at this point to find psychiatrists who I think are qualified and would be making this type of a determination, because the science and the medicine of psychology and psychiatry has kind of really moved beyond the 1948 conception of a person that's a sexual psychopath.
Are you mentioning that because that adds to the delay? I read the transcript from the hearing, and it sounded like there was a lot of discussion about experts and doctors. But is that your point, that it's so hard to find these people?
Yes, I think this will contribute further to the delay.
Can I ask you about your understanding of Mr. Edwards' current status? Am I right to believe that as of present he is at St. Elizabeth's?
He is at present at St. Elizabeth's.
And is it your view that, well, and do you know whether, or does the record reveal whether he is currently receiving services directed at restoring him to competence?
No, because
you don't know whether he is, or
I don't know, but I would venture that he's not, because the competency proceedings are no longer going forward. They've been.
Well, I know they were stayed. I just wondered what that means practically in terms of Mr. Edwards' day-to-day. And relatedly, given that they are stayed, is it your position that it is unlawful for Mr. Edwards to be being held in St. Elizabeth's rather than being held under such authorities as there are under 1322 alone?
I'm sorry.
If your point is, I took your argument to be, in a way, that the competency proceedings are stayed. Nobody should be doing anything that relates to competence. And the trial court also said what is holding Mr. Edwards is not the competency matter, but is 1322. And I was just trying to make sure I understood how that is working conceptually in a setting where Mr. Edwards is being sent to St. Elizabeth's, which seems to be an action that is justified by maybe legal only under the competency provisions rather than under 1322 itself. And so I just want to make sure I understand your view of to what extent, if any, Mr. Edwards' current situation is lawfully influenced by the fact that at one point there had been, and there is a stayed competency proceeding relating to him.
So I think in both scenarios the detention is illegal.
I definitely understand your point about 1322, but I just want, is it your view is that leaving aside 1322 in a way, Mr. Edwards his condition should not be affected by the stayed competency proceeding. He shouldn't be in St. E's because that's something you do to people who you are actively trying to restore to competence, and that's been stayed right now. Is that your view?
Yes. And I think that ends up getting to kind of a Jackson v. Indiana issue, right? Mr. Edwards is essentially committed to a facility, and there's no progress being made towards competency, and so it can't be through that route, right?
Well, again, I don't really know. as far as the record reveals, at least, I couldn't find anything that suggests whether people are, in fact, whether they should or shouldn't be in your view, whether people are in fact trying to restore Mr. Edwards to competency right now. I have no idea. I don't really know.
I don't have that information. I would venture not, given the posture of the case. I'm sure DVH is aware of the fact that the competency proceedings have been suspended. The Jackson hearings have been vacated. These things aren't going forward. And so I don't believe he...
And how do you think that, in a case, for example, in a competency proceeding where there is, let's say, a dispute about involuntary medication, as it might relate to restoring somebody to competence, there are some provisions inside the competency procedural statutes that operate to toll the time limits of the competency process in certain settings, including for, I think, that one where there's a dispute about whether someone can be forcibly medicated or not. And is it your view that when those proceedings are essentially being told because of a dispute about something like forcible medication, that that proceeding is stayed in the strong sense that you're describing, where nobody should be actually trying to restore, otherwise trying to restore the defendant to competence? Or?
No, because I think I understand the question. No, because what would still be happening, I think, in that world where a person's competency proceedings, the issue is whether medication's needed, that all still centers around the determination of whether this person is in fact restorable in the foreseeable future. And so that falls squarely within the statutory authority to, I don't know if toll is the right word, but to permit continued commitment and treatment. That's for competency.
And can I ask you, sorry to belabor this, but I had thought that it was an aspect of your position in the trial court that even if this is understood to be solely a Sexual Psychopath Act proceeding right now that is moving ahead, that your client's competence is still an issue that needs to be resolved, addressed, maybe solved inside the compass of that Sexual Psychopath Act proceeding. Is that a correct understanding of your position?
It is, and now this question isn't squarely before the court, but it was presented in Tilly. I think the persuasive argument is that an incompetent person actually can't properly fall within the SPA because the term insane, when it was used in the SPA, was synonymous with incompetent.
Yeah, and leaving aside the merits of that position, I'm just a little puzzled about the relationship between it and your sense of your client's lawful or current status. Because if you're right about the idea that actually competence is still at issue, properly understood, it has to still be an issue even though this is a Sexual Psychopath Act proceeding, then is it correct or not correct? Does it follow that actually your client should be at St. E's and people should be trying to restore him to competence, and that maybe the various stay provisions of 1322 therefore are applicable by their terms, because, or should be applicable at least, because competence should actually still be grinding along right now?
So I guess, so if we bypass the not insane, means also not incompetent section of it, then yes, I guess is the answer. And I think that this pulls us a little bit of...
Sorry to interrupt, but I will confess that my question was so confusing even to me that I have no idea what you mean when you say yes. And that's not that is not a criticism of you at all. My question was way too complicated.
No, I guess what I'm trying to get at is this. So stepping back as kind of a general matter, the way the SPA is structured, our contention is that it would require, the hearing would require a patient, an SPA patient, that's what they're termed, to be competent to participate in that proceeding fully, because the SPA is ultimately going to litigate whether past offenses, criminal conduct, happened or didn't happen, right? Contemplates, and I wouldn't even say contemplate, it would require essentially the complainants to testify, witnesses.
And I have that line of argument a little bit, although it hasn't been briefed and isn't squarely in front of us, as you correctly point out. But I just want to make sure I understand, do you agree or disagree with the following? If you're right about that, then actually, unless you think 1322 is completely inapplicable, assume for a moment that we didn't agree with that and we thought instead the issue is, can you fit within its tolling requirements? If you're right about that, then isn't the logical conclusion that should follow that this case does fit within the tolling requirements? Because if people were handling it properly, we would still be trying to restore your client to competence in connection with the Sexual Psychopath Act proceeding, and therefore, maybe, if you think 1322 is applicable, which I know you don't, the tolling provisions relating to competence would come into play. What's wrong with that somewhat convoluted question?
I understand. So the mismatch there is that the tolling provisions in 1322 are geared towards getting somebody to competent to get them to trial. And I think what the court's really referencing here is 1322H4C, which specifically discusses, I think, the period that's quote unquote attributable to a person not being able to participate in their defense due to mental incompetency. And there's three reasons why that tolling provision really doesn't apply here. And the first is just kind of in the language of that provision itself. The second is kind of the interplay between that provision. It was clearly meant to work in conjunction with the competency statute to get somebody to a trial to facilitate kind of the requirements of Jackson, Indiana. The third is that to read that tolling to apply to the SPA would work some semi-absurd results, because a person that was incompetent and in SPA proceedings would have their no bond prevented detention continued indefinitely for, say, 100 years, and a competent defendant that was in SPA proceedings would not have their clocks tolled and would still get.
Although that distinction, the distinction between the tolling effect relative to competent defendants and incompetent defendants exists outside the context of the SPA, and if it's an absurdity, then I'm not sure it's distinct to the SPA, because for defendants who are not the subject of an SPA written statement, there is tolling if there is a competence dispute. It could be for a long time, whereas if they're not competent, then there are these 100-day deadlines, and off they gallop.
So I guess let me then go back to the first part of that argument, which is the statutory language in H4C itself, right? So H4C is very clear that these periods of time, they're excluded if, and I think the language is, it's any period that's attributable to the inability of the defendant to participate in his or her defense because of mental incompetency. Now, that attributable, I think, word is the key term here, because if a person is subject to SPA proceedings, then the period of time where the person, say, can't participate in his or her defense to go to trial isn't attributable to mental incompetency at all. It's attributable instead to the fact that the SPA statement was filed and the person was removed off of any competency track, off of any going to criminal trial track, and instead moved over to a civil commitment track.
Well, your argument basically, as I hear it just now, is the old expressio unius argument that it's not included in the subsection H for and its subsections there, and that you can't interpret it or wiggle it in a direction that would defeat an expressio unius argument. Isn't that really what your bottom line is?
It's that plus, when we look at the statutory language and the authority to detain, this court has been very clear, right, for decades. In Hazel in 1984, reaffirmed in Best in 1994, that there's no authority for the trial court to detain unless it's expressly in the statute, and it's not there. So it's the canon of construction plus when we just look at the language itself and the commands of this court previously. Now, going a step beyond that, I think the legislative history underlying the tolling provisions also made clear that it's never meant to encompass the SPA. And so the tolling provisions were put in 2001 as part of the Bail Reform Act amendment. Bail Reform Amendment Act of the year 2000. And the legislature made very clear at that point that they were putting in specific explicit tolling provisions essentially to avoid confusion, to set out the acceptable circumstances in statute, and to prevent, I guess, excessive litigation or litigation.
Can I ask you a question about your understanding of what the trial court did here? You're mentioning the specificity of these provisions. Do you think the court was determining that there was specific legislative authority and it lay in 1322 H4 B and C, I guess, and that those actually somehow applied specifically, or was the court saying something mushier, like, these provisions talk about insanity and competence, and, this is a psychopath thing, they're sort of the same, and is it more, a vague kind of inherent authority kind of ruling, or it seems like in your brief, you're saying he applied B, and C, but I'm not sure that sounds exactly right.
Oh, no, 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 I'm sorry. Our position has not been that the trial court actually pinpointed an explicit statutory exception or a tolling provision. I think it's the latter, as Your Honor described. I think the trial court's decision was much mushier than that, and the government essentially concedes that there's no explicit provision that provides, which is why they're reaching back to try to use this word stay in the way they are. I mean, the government's position, I think, from my understanding from the pleadings, is not that there is any tolling provision that applies. Their claim is that tolling isn't really a consideration at all because the word stay would somehow cover and encompass that so that there wouldn't need to be reference to.
Would you agree or not agree that at least sometimes the idea of staying a proceeding would logically imply staying the deadlines that would otherwise have been applicable in the proceeding?
In certain circumstances, I think so, but again, we're talking about detention and the purpose of that detention. And so I think this becomes a very different issue. And we ended up briefing this a lot, but this isn't, say, a motions order calendaring something that's being stayed, right? This is the staying of a statute. It's narrowly tailored, designed to do very specific things, talking about 1322 here, with very, very strict time constraints when it was created. And it survived constitutional challenge under Edwards and Salerno because it was so narrowly tailored, because there were these strict time frames. And to me, it's somewhat inconceivable to say that, well, the legislature must have intended to allow it to kind of expand indefinitely to a civil commitment proceeding that has no time frame limitations whatsoever. And beyond that, I think what's clear is that the purpose underlying 1322 is to safely get a defendant to a criminal trial, not to just any proceedings in general, but to a criminal trial in particular. And the SPA essentially works to defeat that purpose. The SPA prevents a person from proceeding through the necessary stages to get to a criminal trial. And once that purpose is defeated, and what the Supreme Court has said, first in Jackson and then in Zavitas that we cited to here, that once that purpose is defeated, the detention is no longer authorized.
Can I wrap back around? I apologize for wrapping back around to this topic that I always find confusing, but could you try to clarify your position about the interaction between the proper understanding of the interaction between the SPA proceedings and competency proceedings? And let me ask it this way. So imagine there is a case in which there hasn't yet been a dispute about competency, and either the government submits or the trial court sua sponte directs the government to submit a sexual psychopath act statement, and one is submitted. And then a question arises about the defendant's competence. Is it your view that although the SPA has the provision about staying the criminal proceeding, that really shouldn't be interpreted to operate to stay the operation of the competency statute? And therefore, what should go, the statement can remain in place, and there is a stay of the criminal proceeding writ large, but there is a need to go through the competency process, and the Constitution requires it, and the statute provides for it, and Constitution at the outer limits requires certain things, and that statutory scheme should operate, and its deadlines should be observed, and its processes should be observed. Is that your position about how things should operate when they are operating properly, or is that something different from your position?
So I think it's a difficult question to answer because, and this is part of the problem with reaching back to a 1948 statute that deals with people in such an antiquated way and uses such antiquated language, like insane. To proceed on that track, our position is that a person in SBA proceedings must be competent to properly go through it. To facilitate that, what the court would, I think is kind of saying here, what the court would actually have to do is to create a new route from the SPA into 24-531, the competency statute, which is created for pretrial going to criminal trial defendants. And that provision doesn't, it's not there. And this is an omission, it's not for us here now to kind of rewrite that, to create these
Are you
pathways.
saying that, do you think there is some language in the competency statute that makes it explicitly inapplicable? Leave aside the stay language in the SPA, but are you saying that also the language of the competency statute makes it inapplicable by its terms to a defendant with respect to whom a Sexual Psychopath Act statement has been submitted?
Yes, I believe so. I think 24-531, the purpose of it, was created to facilitate competency determinations, competency restoration for defendants that are in criminal proceedings headed towards a criminal trial. I don't think in any way, shape, or form was created to address a competency issue as it applies to people in the SPA.
Right, a different way of looking at it, leaving aside, I know you're talking about purposes, and I was asking about language, slightly different concepts, but another way of looking at it is that the competency statute is directed at ensuring competence in connection with criminal proceedings, and that someone who has a criminal charge pending but also a Sexual Psychopath Act statement filed may or may not be headed towards criminal law. We don't know yet. And so it's conditions of uncertainty, and it may be that the competency statute should be, unless its terms say otherwise, should reasonably be applied to someone who is in this situation where there's a pending criminal charge. They may or may not ultimately face it. There are other proceedings that may or may not, render that academic. And so to me, I'm not sure that the purposes make your answer so clear. Maybe the terminology of the stay language in the SPA, or maybe the terminology of other provisions in the competency statute do, but it's not immediately apparent to me that it, by its purpose, it would make no sense for it to be applicable to a defendant as to whom a Sexual Psychopath Act statement has been submitted.
I understand what the court is saying there. I think I guess in terms of what's been happening in this case, it becomes kind of a moot issue because the defense, we asked Judge Lee to still go forward with this competency determination. I mean, that's where we wanted things to go. That's where we think it properly would go.
Although if I understand your position, not pursuant to the statute because you think it's inapplicable, but in some more free-floating way that might be dictated by the Constitution and Jackson and the like. Is that?
Our position is that that's the first determination that needed to be made, and the trial court declined to do that. And I guess this leads me to kind of the absurd results argument that the government posits, the boogeyman argument that, well, if things proceed in this way, dangerous sex offenders would just be released. That's really not the case, and that ties into kind of this competency issue. So, we have in 68 and 69, the DC Circuit and Millard and Cross basically saying that this statute is, in effect, kind of dead in the water. It's basically defunct. That it's going to be very hard to see a world of people that fall into the SPA but don't fall into 1964 Urban Act. They weren't willing to go that far because there was still, I guess from their conception, possibly a quote-unquote commitment gap that necessitated the existence of the SPA. But at this point, that gap has been fully closed. So in 2002, I believe, the DC Council passed the Civil Commitment of Citizens with Mental Retardation Amendment Act, and they renamed that to be the Citizens with Intellectual Disabilities Act. And when they enacted that, the government, the USAO's request, the statement purpose was to establish an involuntary commitment procedure for persons with mental retardation who have been charged with a crime of violence or a sex offense, who have been found incompetent to stand trial or to participate in sentencing or transfer proceedings, have been found not likely to gain competence in the foreseeable future. And so through that, through the I guess I'll call it the CIDA now, the CIDA creates an avenue to address specifically the people in Mr. Edwards' position, person who, due to intellectual disabilities, cognitive functioning, is incompetent and may or may not be a dangerous person in terms of being a sex offense recidivist. And so there are these two viable paths to civil commitment. Both of them actually include pre-hearing detention authority. Now, we call this the bridge provision, and that's an outgrowth of the the competency statute in 24-531-06 subsection C. And that provision gives the trial court authority when a defendant has been jacksoned to continue the treatment, the commitment at St. Elizabeth's for 30 days to see if the government's going to file a civil commitment petition under the Urban Act or the CIDA, and then allows that treatment period to then continue to cover the pendency of the civil commitment proceedings. So what we have are two modern, viable methods that provide the detention authority that the government wants, two viable, modern civil commitment proceedings that would get to basically everybody covered under the SPA. And the government's made kind of this strategic choice to ignore that and to instead reach back to 1948 and to create kind of this problem that we have now, and to ask for detention authority where the statute just plainly doesn't provide for it, not in the SPA itself or in 1322. And that then kind of gets, the government shouldn't be able to say, well, we need to have detention authority. There should have been detention authority, and to give us detention authority in this SPA context, where they've chosen to go with something that clearly doesn't.
Can I say, you said 1322 doesn't provide detention authority in this circumstance, and leave aside for a minute deadlines. I understand your theoretical argument that the purpose of 1322 is to impose conditions on liberty with an eye towards criminal prosecution and trial and conviction and the like. And if that's not the track things are on, then 1322 shouldn't be understood as conceptually available. I have that line of thought. But leaving that aside, are you suggesting, I mean, I would have thought that by the terms of 1322, it does provide for detention authority for people who are like your client, who are charged with a criminal offense. And so are you tying anything to the, again, leaving aside the deadlines, but just in terms of it applying for some period of time, are you tied to the language of any particular part of 1322, or is your sole argument, I don't mean to disparage it by saying sole, but is your sole argument the conceptual one that it just shouldn't be understood to apply because it has a context that isn't applicable here?
No, I think it's tied to the language itself. Nowhere in 1322 do the words sexual psychopath act appear. Nowhere in 1322 does the statute give any authority whatsoever to deal with people in SPA proceedings. It's just not there.
Well, what it does do is, by its terms, give authority to detain people who are charged with certain offenses and as to whom certain findings are made. And there's language that seems to make it applicable to your client. And then I guess your argument is that the word stay in the the SPA should be understood to displace that authority, either, I guess, as a matter of statutory interpretation or the like. But, I mean, there is language in 1322 that seems to apply to folks who are in your client, who are charged as your client is, and with respect to whom the findings have been made that have been made as to your client.
I think I think the problem there is that it has to go beyond somebody that's just charged with, right? Because 1322 can't be read to be removed from the expedited trial calendar portions of it. It's very clear 1322 is structured specifically around that time frame, and that's kind of what we were talking about earlier. That's why the statute survived constitutional challenge, because it was so narrowly tailored, because of these time constraints. And to say, well, we can throw all these time constraints out the window and only rely on the fact that a person was charged, when there's really no possibility at this point that a person can actually go to trial in the expedited timeframe. I
If this
think
were just a competency proceeding, no SPA at all involved, how would your client have been treated? And what would have been the limitations on detention, or would detention have even been called for?
So I think we would be in the posture that we were in immediately before the filing of the statement, which is that Mr. Edwards was essentially some days away from a contested competency proceeding, where the court would have made a determination on whether he was competent or incompetent.
I
whether
thought there
he
had
was
already been a
restored.
determination he was incompetent, and the issue would have been whether his competence was likely to be restored, or am I?
So I think that's not the necessary conclusion. So there were kind of competing expert opinions. DBH and St. Elizabeth's had found Mr. Edwards competent.
I just thought at some point the trial court, without objection from the United States, said, I find Mr. Edwards not competent.
After the preliminary screen, Mr. Edwards was found incompetent. He was then sent to St. Elizabeth's for further evaluation
I see. So
and treatment.
as
And
yet
so there had
undetermined.
not been I guess,
I
a
got you.
formal Jackson kind of finding.
There hasn't been a
That's what they
formal
were-
finding yet about whether he's already been restored, though he was not at one point
Right.
competent.
Well,
And then the related question of whether, if he hasn't yet been restored, whether he is reasonably likely to be able to be restored. Those are the issues that you would have understood to have been contested at the imminent Jackson-type hearing.
Correct, because
Got it.
you essentially had three different experts with each of those possible
Got it.
opinions.
But to
Thank you.
what extent was detention a part of that analysis, what was happening?
So, Mr. Edwards was detained. He was committed to St. Elizabeth's for the competency examination plus any restoration treatment that was necessary. That's the posture of the case. That's what we would return to if he goes back
If there'd
into
never been
competency
if there'd never
proceedings.
been an SPA statement filed,
He would be under 24-531, going through that competency route, with the end goal, the determination being the contested competency hearing that was
to what
short-term.
extent, if any, does the 1322 have a bearing on how he would be going through that proceeding? None?
1322 would be tolling time via
Under the
H4,
subs.
H4C,
C,
working hand in
right.
hand with 24-531.
Right.
Correct.
And so right now, we're trying to decide whether that aspect of what's happening to him has any difference because of the SPA proceeding in terms of whatever is going on with that 1322 subsection.
I would say it does, because Mr. Edwards is no longer progressing towards a contested competency hearing. There isn't one. There's, at this point, no hearing set. There will be no determination made as regards this question, right? Whether he's competent or incompetent, whether, if incompetent, he's restorable. That hearing was vacated. This is done. He's outside of that track, and he's now moved over to the SPA, which unfortunately doesn't include any of that and doesn't seem to have a bridge that gets it over to the 24-531 scheme.
Okay, we will give you some time on rebuttal. Thank you very much.
Thank you.
Let's hear from Mr. Smith.
Good afternoon. May it please the court, Peter Smith on behalf of the United States. The trial court did not err in maintaining appellant's detention pending the SPA proceeding in this case. I wanted to start out by noting that the United States believed that the SPA proceeding was the only path forward in this case at that point, and that the alternatives were unavailable. And some of those alternatives were discussed earlier today during appellant's presentation. The Irvin Act applies to persons who are mentally ill, and we believe does not apply to appellant. Appellant argues himself that he's incompetent because of an intellectual disability. The Citizens with Intellectual Disabilities Act, the CIDA, we believe doesn't apply to appellant either, because in order for commitment, the government would have to prove that appellant's conduct was a result of his disability. So I wanted to give that by way of background before I began this morning. The government's primary argument is that the stay provision in the Sexual Psychopath Act, the SPA, has stayed the proceeding and that has maintained the hold that existed prior to the stay that comes from the Bail Reform Act.
Can I ask you how far you take that? So imagine a case in which a defendant is charged with an offense that under the provisions of 1322 would permit a 5-day hold for there then to be a determination of probable cause and the like. Is it your view that if the United States one day into that files a Sexual Psychopath Act statement, that the effect of that statement is to toll the 5 days requirement and to toll the requirement that someone make a probable cause determination and the defendant can just be held based on the fact that there was a 5-day hold and the 5 days are now tolled indefinitely?
I think the answer is yes, Your Honor, and I guess on the back end of that question is, what sort of limitations would be on that hold as the SPA proceeding played out.
And let me just, that's the front end, let me just ask you the back
okay.
end. One can also file a Sexual Psychopath Act statement with respect to someone who's on probation. And is it the United States' view that if, let's say, a defendant is on, a 1-year term of probation and the day before probation runs, the United States files a Sexual Psychopath Act written statement that the period of probation that was ordered is, because the criminal proceeding is stayed, the running of the days of the sentence is stayed, and the defendant is therefore on probation indefinitely until completion of the SPA proceeding?
I hadn't thought about that particular hypothetical. I guess the answer is yes, that it would be stayed until, the SPA proceeding were concluded. The SPA
to me at least, those seem as somewhat surprising consequences.
Well, I guess I would return to the point I was trying to make earlier, which is that in the usual context, or the context that we have here, where appellant, it was pending criminal trial and there were competency proceedings, and now that has been stayed by the filing of the SPA statement in the criminal case. In that context, one would think, well, appellant has argued that this detention would be indefinite and that there's no limitation on that. And our response to that is that it wouldn't be indefinite, that appellant would have recourse, constitutional recourse. He could file a motion for release, he could file a habeas petition, and Judge Lee had made clear that the SPA proceeding was going to be expedited. And this brings me to, I have a couple of factual disagreements with appellant's presentation.
Before you get onto those, isn't it sort of odd to require the defendant to take advantage of all those things you just mentioned, when we're talking about detention, something where there's so much case law indicating that you have to have specific authority to have it. It's the presumption is liberty. It's odd to say, well, it's not going to be indefinite. I'd also be curious to know how we know that. It seems like we don't necessarily know that, but also, and you can file a habeas petition, it'll be fine, or just wait until it's unconstitutional, whenever that is. It seems, antithetical to the norm of specific statutory authority.
I think there is statutory authority. I think that as Judge Lee did, this court needs to look at the statutes together. And the two statutes together, the SPA and the Bail Reform Act together, provide a vehicle for the detention. So
you're asking the word stay to carry so much, and I don't understand why stay necessarily means stay the pretrial detention.
The Sexual Psychopath Act, the SPA, sets forth the stay. It says the criminal proceeding is stayed. It predated the enactment of the Bail Reform Act. So the way that they would operate together would be to maintain the stay. And then as to the other aspect of the court's question about how we would know it's not indefinite, the legal answer is that appellant would have recourse, but the factual response, and here I disagree with what appellant's counsel said earlier. Judge Lee indicated that the proceeding would be expedited. Judge Lee had selected psychiatrists. Now, appellant had said that the psychiatrists weren't appointed. That may be technically true, although I'm not sure. But he certainly had selected them and indicated to the parties that he was going to go forward and retain those. The case is now before Judge Dason, I believe. But the SPA proceeding is farther along than I think appellant was indicating earlier today.
Are you in a position to provide any estimate of how long that proceeding could be expected to take?
We believe that one of the reasons that the United States filed the SPA statement was because we believed it was a more efficient, faster conclusion to this case. And I mean, just as a rule of thumb, I think that we would be able to conclude the SPA proceeding within 6 months or so. I mean, obviously, it could extend longer than that, but
Can you answer the question of whether at present Mr. Edwards is receiving services directed at restoring him to competence?
he is.
And do you think that is legally the correct way of proceeding?
I guess my response is it's not legally required because of the function of the SPA stay, but at least in partial response, I would say that since he is being housed at St. Elizabeth.
Is it lawful for him to be being held at St. Elizabeth's right now?
The parties haven't argued that he shouldn't be housed there. Appellant has never argued that he should be held at the DC jail. That is an interesting question, and it sort of follows from appellant's position that he should be at the DC jail, not at St. Elizabeth's. But the government hasn't asked for that, and appellant hasn't asked for that relief.
Mr. Smith, I'd just like to try to get a little perspective on this. I take it that the heart of this case, in a way, because of the SPA statement, is a concern, a perceived danger of this individual, right?
Correct.
So you would think that the legislature in 1322 coming around to put 100-day limitations expressing concern, obviously, for liberty up to a point of detention, didn't put in here any reference to this situation when it made these exceptions under sub A, B, and C of sub 4. And so now we're in this position of basically saying, oops, there was a big mistake here, and we're going to try to cure it. At least the feeling that we're getting from this, because we're really stretching here to get around what is the obvious place for this to be done. In that context, what is, in your judgment, the strongest reason to avoid getting tangled into that limitation?
I understand the court's concern, and I think our response is that there wasn't any need in the Bail Reform Act to have specific tolling provision for the SPA proceeding because the SPA, which predated the Bail Reform Act, has the stay provision. So unlike the CETA or the Irvin Act, there was no need for a tolling provision because the SPA already had a stay provision. There was a need for tolling in these other contexts because those other statutory contexts, the Irvin Act and the CETA, lacked a stay provision.
Can I ask you, I mean, some of this wraps around to what you conceptualize the status quo as being, because your argument is, look, there's a statutory provision in the SPA that says stay, and so we're just going to freeze the criminal proceeding. But if you think of the state of the criminal proceeding as there having been an order that said the defendant can be preventively detained for 100 days, if that's the way you conceptualize the proceedings at the moment of the filing of the SPA, then if you freeze that status quo, then the defendant can be detained for a fixed period of time, and if that period runs, then somebody's got to do something different, but you're not freezing the status quo if you end up allowing for detention beyond that. What's wrong with that way of looking at that?
I guess, I think it does cut to what the status quo is, and I think the status quo, the way that we would look at the status quo at the time the stay is entered on the court's docket is that the defendant is being, in this case it's appellant, but that the defendant is being held at that time, and that whole.
So you would interpret, when the trial court issues an order of detention, you would say that under 1322, you would say that the right way of understanding is that it's indefinite and it would require a further order of the court to permit release of the defendant even after the 100 days runs. That's how you would conceptualize things.
I think so. Yeah, I guess so, yes. You know, in the normal criminal case where these weren't at issue, you would have either the time running or you would have the tolling provisions. But here you have the stay from the SPA. And when you look at the two statutes together, as Judge Lee did, we think that that's the most reasonable way to understand the operation of the two statutes together here. I guess I would add, you know, as further support for that point, I guess I would point the court to a case like Shelton, for example, where the statute being the Sexual Psychopath Act, the SPA was silent on a question. This court addressed that question. In Shelton, the court found that that the defendant in that case would get credit at sentencing for the time served under the SPA.
I can ask you this idea that you freeze the status quo. So just imagine a case where a defendant is charged with a criminal offense and is on release, let's say just on personal recognizance, and then the United States files a Sexual Psychopath Act statement. Is it your position, so let's say there's an issue that arises where there's an inappropriate interaction between the defendant and the complainant in the case, and the United States would be interested in getting a stay-away order as a condition of release, so wants to modify conditions of release. Your view is can't be done, the status quo is frozen by the filing of the Sexual Psychopath Act statement?
I think so. That's an interesting question. That's sort of about what the stay means. It's not entirely clear, but I guess my inclination would be that there would be a stay and that the court wouldn't have the authority to modify the conditions. But I don't think that we certainly don't have that case here. That's not the issue for appellant, but I understand that would be a harder case, and the answer is not entirely clear. But I think that it follows from our position that the court wouldn't have authority to modify the conditions. But
Does your point about how expedited these proceedings will be, does that go to the statutory interpretation, or how we analyze this this question, or are you just saying, what if you had a judge who didn't have the sense of urgency that you're saying Judge Lee or maybe now Judge Dason had? Does that change how we construe the way these statutes work together, or it's just then the defendant is going to have to take advantage of other means to get out?
I don't think it informs the legal decisions that this court makes. I think that we are making an argument, a factual response to appellant's claim that this is tantamount to indefinite detention. And our response to that is twofold. One, on the legal side, it's, he does have recourse. If it becomes a constitutional issue, he can file a motion for release or a habeas petition. And then on the factual side, which Your Honor is asking about, not only did Judge Lee say the proceedings would be expedited, as I mentioned before, we think that if the two experts haven't been retained, they'd have at least been identified, and that the proceeding is already moving forward. It was the United States' belief when we filed the SBA statement that it would proceed faster potentially than the competency proceeding. The competency proceeding, especially if would be a contested proceeding, it could take a fair amount of time. And then if you have competency restoration, it was, in our view, a better, more efficient alternative to follow the route of the SPA proceeding for that reason. It was already far along. Judge Lee had indicated he would expedite it. We believe that, all things being equal, meaning no external litigation, no other litigation.
What was already far along?
I'm sorry?
What was already far along? I thought you said that I thought I heard you suggest that the Sexual Psychopath Act proceeding was already far along.
Not that it was far along, but that it was underway.
Because it seems like the competency proceeding was the one that was, I don't know about far along. It certainly had
Yeah, I think I was
had
mixing.
been going on for a long time already, at least.
I think I was mixing times, and I apologize for that. Not at the time of the filing of the statement, but at at the time of Judge Lee's decision or now, the proceeding has moved forward, meaning that the psychiatrists have been identified and
Can I ask you about the interaction between, your position about the interaction between the SPA and competency proceedings? Well, first, do you agree that it's at least potentially a contested question whether at present Mr. Edwards is competent?
I agree, it is theoretically, that if the competency proceedings were to return, that it would be a contested question. I think that's
Whether
what-
he is or is not at present, and then also the question of likelihood of restoration?
At present, the SPA, I don't think that the parties are contesting competency because of the stay and because of the SPA proceeding.
Understood. I was asking you just about what the position, what the likely positions of the parties would be. But let me, I do want to shift over to that. So is it your view that, do you have a position on your opponent's argument that as a matter of law, it's not permissible to pursue, this is a paraphrase, so hopefully I'm paraphrasing it correctly, but it's not permissible to complete a sexual psychopath act proceeding with an incompetent defendant, and therefore that competence becomes an issue inside of the SPA proceeding? Do you have a position about whether that is correct or incorrect?
We do. We believe that's incorrect, Your Honor. That is one of the questions that's before this court currently in the Tilley case. Tilley is very similar factually to this case, and it's on appeal, and that's one of the issues that is pending.
And is it your position that the stay that is created by the SPA precludes competency proceedings under the statute? Leave aside whether as a matter of law they're required or not. The question would be whether it would be permissible for a trial court to say, I understand that there's an SPA statement, but I'm going to go ahead and in parallel run through the statutory competency system. Do you think that is unlawful because the SPA stay prevents it, or because the provisions of the competency statute make it inapplicable once an SPA statement has been submitted, or none of the above?
I believe that the pendency of the SPA proceeding would stay the competency proceeding, but I don't think that fully answers the court's question. So as to what the court can do, I think judicially, the court can't move forward with the competency proceedings, but the court also asked earlier about what's happening exactly with appellant at St. Elizabeth's currently. My view about that is that he is currently hospitalized at St. Elizabeth's, separate and apart from the pendency of the SPA proceeding or the competency proceedings pending in the court. The hospital has a duty of care to appellant, and pursuant to that duty of care, they are continuing to treat him, and that is something they are doing.
Well, although they certainly have a duty of care to treat him, whether that duty of care extends to a form of treatment that is devoted to restoring him to competency with respect to particular proceedings is less clear to me. But
That point is well taken, and I don't express any position on that. But and also my response about St. Elizabeth's is merely a practical or factual one. It's not. We're not saying that it necessarily follows, given the court's questions earlier about.
But your position. Excuse me, go ahead.
No, that's fine, go ahead.
No, I just want to be sure I understand your position. Is it that the SPA proceeding that postpones, we'll say, or stays a criminal proceeding, by definition stays or postpones the competency proceeding that's part of that criminal case? I mean, that's what you're getting at, right?
Yeah, I think that is our position, or that's the thrust of our position, that the stay.
And as Judge McLeese says, that might not preclude some kind of treatment that would be necessary given the personal condition, but it wouldn't have nothing to do with a formal competency determination with regard to a criminal proceeding.
I think that's right. I mean, one could argue that the competency proceeding is kind of continuing in the background while the SPA proceeding is also continuing. The United States hasn't made that argument on appeal. So, I mean, I understand that argument.
I thought your answer to the question I asked you was to suggest that you don't agree with that line of thought, that you think that the correct understanding of the function of the SPA stay is that it operates to terminate the trial court's authority to conduct statutory competency proceedings under the competency statute.
Yeah, I would agree with that. I think that's right. The trial court can't take, I interpret that to mean, or I understand our position to be that the trial court can't do anything with respect to the competency proceeding.
Can I ask
But
you
I was distinguishing that from practically what's happening. with
Understood,
appellant.
understood. Can I ask you the question that I think Judge Beckwith asked your opponent, which is how you understand Judge Lee's ruling? Do you understand Judge Lee to have found that one of the specific tolling provisions under 1322 is applicable here? Or do you understand Judge Lee instead to have been drawing an analogy to them and relying on that analogy as support for the idea that detention is appropriate here?
I understand it as the latter. I mean, I can see a reading of Judge Lee's decision where he is actually applying the tolling provision, but I don't believe that's what he did, and that's not what we hadn't taken that position in our pleading. And consistent with our pleading and what I believe is that Judge Lee was kind of musing, and he was using that as an analogy. And he was saying, look, SPA is like competency. It involves sort of the mental fitness of the defendant, and it's very similar. So I think it's the latter.
There was a lot of discussion at the hearing about unavailability. He seemed very focused on, the specific tolling provisions, but how did that, I don't think you're arguing that in your brief anymore, but it seemed to be a big issue in the trial court. How was that shaken out?
We're not advancing that argument currently, and I don't think that was the basis for Judge Lee's ruling. Judge Lee made a lot of comments and now I'm talking about the December 3rd proceeding, the hearing. So he made a lot of comments and questions that were sort of along the lines of musing, but I think his actual decision or his ruling was that there was a stay. The stay sort of suspends or freezes the proceeding, and that part and parcel to the stay is that appellant continues to be held under 1322. And that, I believe, is the argument that we made in our supplemental pleading. I believe that's our strongest argument. I believe that is what Judge Lee ultimately did.
Do you think there's a lot of reference in your pleadings to keeping the community safe? Is that what you think is the justification for this particular detention?
For appellant's detention? Or
Yes,
for
I mean, you talk about how his being dangerous and, there's just a thread, through all of your pleadings that's like, this guy's dangerous, that's why this is okay.
We do believe that he's dangerous, and we do believe that the hold or detention is permissible and is proper in order to protect the public. It sort of begs the question of in what context.
You're right. I guess my question is, when people are charged with murder in a pretrial detention situation and there are findings made about them being a danger to the community, there are still these strict time limits. They're dangerous too, and this, seems quite different from that. It seems maybe not indefinite, which you push back against, but definitely not a limited time period.
Right. Well, I guess I had two responses, Your Honor. The 1325, which would be the hold for murder, doesn't have the 100-day time limit that 1322 has. So the measure for release, among other things, would be the constitutional measure, and that would be much longer than 100 days. So that's one response. And the other is a practical response, or a factual response, which is the court did make findings about appellant initially. That's why he was held under 1322 in July or August of 2018. So it did make those findings, and we do have those. So we're not arguing that the stay somehow could operate independently of any finding under 1322 or something like that.
Well, suppose you were to lose this appeal in the sense that he's free to go. Wouldn't somebody initiate a civil commitment or just a garden variety civil commitment proceeding and keep him there?
We, like I said before, we do believe that he should be detained, And we do believe he's dangerous and should be detained to protect the public. And I think that if he were released, if this court were to release, to enter an order rejecting the government's position and, ordering release or finding that tolling had run, or, I'm not sure exactly what that would look like, but if he were to be released, the government would have to reevaluate what it was going to do at that point. But
Wasn't that an obvious
yeah,
possibility?
I mean, I would, it's obvious now. I mean, I guess I'll answer your question in two ways. Initially, we would take steps to try and ensure that he was held. We don't know exactly what that would be. We'd have to evaluate when that came about. It may be, the potential may be obvious.
What's the impediment to proceeding back into the competency train? Makes it seem like it's moving a lot faster than it was, but the competency/incompetency route.
I mean, I'm not sure I totally understand the court's question. We could go back to the competency
At the time
proceeding.
you filed the SPA statement, the defendant was being held pursuant to the competency statute. And your opponent has indicated that, on his view of things, that can't happen when there's an SPA statement pending. But the implication is that if the SPA statement were withdrawn, that the detention pursuant to that could resume, subject to the further proceedings that are required by the statute and the Constitution.
Right.
Is that somehow an option that is demonstrably infeasible or impractical?
No, it's an option. I think I misunderstood what the questions. If the SPA proceeding were to go away, then we would have to again evaluate. But it's the competency proceeding could resume, and that was something that Judge Lee expected. And I guess,
leaving aside how it would work out here because of the timing of the filing of the SPA statement relative to the beginning of proceedings here, but do you think there is anything intrinsically absurd with the conclusion that the filing of an SPA statement doesn't preclude detention under 1322, but that detention will have to proceed within the time frames established under 1322? Is that some sort of an absurdity? Do you think that's just so obviously infeasible that can't be a logical place for the analysis to settle?
I guess I'll answer it this way. I think the better view of the way the statute operates, the two statutes together, meaning the SPA and 1322, is that the stay is
I definitely
functionally like a
understand what your
toll.
principal
Right.
argument is. My question is, and I understand what your opponent's principal and broadest argument is, but your opponent's fallback argument is, well, even if 1322 detention is not fundamentally incompatible with an SPA, the existence of an SPA statement, at a minimum, any detention under 1322 will have to be under the terms of 1322, including the tolling provisions that are actually applicable by their terms, and there's a good cause extension provision and the like. And my question for you, I know this isn't your position, but my
Right, I
question
understand.
is your opponent's fallback position, in your view, impractical, infeasible? I know you don't think it's analytically right, but I want to know whether, in addition, you think it's just not, it's infeasible or impractical in some way.
It may be, I mean, it's certainly impractical for a variety of reasons because of the time it takes to do these various things. It would be difficult to have an SPA proceeding and comply with a 100-day time limit. So I would say on the face of the two statutes, the
Although
way.
that might depend on how you apply various of the tolling provisions or the way the good cause extension provisions operate. So it seems a little unclear how impractical it would or wouldn't be, depending on the answer to some of those questions, which nobody's.
I agree with that. I do agree with that.
So aren't a lot of what the difficulties are, isn't that really a legislative question? I mean, you look like you're kind of reaching around to find something that fits, but I don't know whether you view this as an oversight or, an oversight that it's fair to fill in with by analogies and cobbling the two statutes together or what, but it seems like something, if this is such a problem, isn't it one for the legislature?
I guess two responses, Your Honor. And our first order response is that, the two statutes are there. They need to be read together. To us, it's not unreasonable to take the position that we're taking and that the court could write an opinion that way. But if the court were to reject that and were to think, this is an obvious oversight or there's something, it's a step too far, then we agree. And the court should write a published opinion so that the government could take that opinion to the legislature and seek a legislative fix. So, I mean,
You don't need that opinion to do that.
not necessarily, but we think, we would encourage the court, if it did think that, to write a published opinion on this, because it is novel, it is an interesting question, and something that we would be able to use with respect to the legislature. But
Is it relative to that, is it accurate, as your opponent suggests, that there are 3 proceedings, at least currently in place, where the Sexual Psychopath Act has been invoked? That might be germane to how serious a legislative problem it might be, or how much it's an issue that calls out for.
yeah, it depends. I guess it depends how you define what the pending proceedings are. I mean, there's Tilly, which is very factually similar to this case. In Tilly, unlike this case, Tilly didn't contest release. This is the first case that we know of where a defendant has challenged detention pending an SPA proceeding. So there's Tilly, there's this case, there's Santos Martinez pending in the Superior Court. There are other SPA commitment committees. I don't know how many. There are other committees currently at St. Elizabeth's. And so there's a universe of, say, something like 5 pending. This is outside the record, and I apologize about that. But in none of those cases, except for this one, did any of the defendants or committees challenge, seek release or challenge detention pending the SPA proceeding. And that's one of the reasons that for this is in part my response to Judge Farron's question earlier. It's obvious now that appellant can be released because appellant has made these arguments and we've had to defend them and think about them. But at the time we filed the SPA statement, it wasn't obvious to us at all. We thought the opposite. No one had challenged detention, and we thought that would be what would happen here.
Do you agree with what I think your opponent said, that the act was sort of dormant for a while? It really wasn't being used?
I disagree with that. There are there are SPA cases throughout from 1948 until now, and those are different sorts of cases. Some committees have basically raised sufficiency challenges, that there wasn't enough evidence to commit them. Some have raised habeas claims. So there's a lot of different kinds of cases. It's been used. I don't think that there was a period of dormancy. I think that it's continued. And this is again outside of the record, and I apologize about that, but some of the current committees at St. Elizabeth's were committed at a time, I believe, appellant is going to say, that was dormant, and the SPA wasn't being used or relied upon. So they've been there for some time. Santos Martinez is pending. This case is pending. Tilly is Tilly. I can't recall offhand whether Tilly was adjudicated as a sexual psychopath or not. So those are the ones that are kind of currently pending. But then there are, as I mentioned, there are committees currently. So, and then there are past ones who have either been released for a variety of reasons. They've been, the staff has deemed them to be treated and have been released, or for whatever other reason, their commitment has ended. So it has been, it has been used over time, and it has been used. And this is actually relevant to arguments about the purpose of the SPA and its reach. But it was used to protect the public, and it was used. I found at least 2 cases, and the names of which elude me at present. But there are at least 2 cases early on where it was used to protect the public from an individual's crimes against children, sexual crimes against children.
Well, it's pretty clear from the legislative history that it was intended, once someone was adjudicated a sexual psychopath, to protect the public. What's less clear is whether the pendency of an SPA proceeding was thought to be a time when there was a need to protect, pre-adjudication. That seems less clear from the legislative history of the 1948 Act.
I would agree, perhaps means, is less clear from the legislative history from the statute itself, but when you read what is in the legislative history about protecting the public, with the fact that for want of a better term, the defendant, if there's a criminal case proceeding, the potential committee in the SPA proceeding, the fact that those persons did not raise challenges to detention during the pendency of the SPA proceeding kind of indicates to me that that everybody, including the defense, thought that there was a sort of pretrial or proceeding need to protect the public. If there are no further questions, we urge the court to affirm the judgment of the Superior Court. Thank you very much.
Thank you, Mr. Smith. Then we'll give you 5 minutes.
Thank you, thank you. So, Your Honors, I want to address just three things. And just first, very quickly, I want to say to some of Judge McLeese's questions, our position certainly is that outside of the SPA proceedings, the posture of the case would move. Mr. Edwards would go back into the competency world. He was pending a Jackson hearing. The defense repeatedly requested the trial court go forward with that. That's our request still today, that he be able to go through the Jackson hearing, and then, like we've talked about, that opens the two paths, Urban Act and the CIDA, the legislatively kind of provided mechanisms for civil commitment. I also want to talk a little bit about the government's contention that the SPA is a more expedited proceeding, and I'd put to the court that that's just not true. So if we look at Mr. Tilley's case, which really is kind of like, from my understanding, the most recent kind of example we can pull for this actually going through. The SPA filing was made in Mr. Tilley's case in February of 2011. Mr. Tilley's SPA proceeding did not go to a hearing, the SPA trial, so to speak, until sometime after March of 2013. And so when we compare that to, say, the mechanism created by the CIDA, it is not in any way expedited. I mean, the CIDA mechanism has kind of the 30-day bridge between the Jackson incompetency finding to the filing of a petition. There's the maintenance of an ability to detain a person in a secure facility if that's what's necessary. And then the CIDA has very strict time frames after that. And I believe that time frame is actually 90 days if a person is detained in a secure facility. And I think that's spelled out in DC Code 7-1303.12a, subsection D. So it's not true that the SPA is in any way, shape, or form more expedited. I think it's actually significantly slower as compared to the CIDA. The other thing I wanted to address briefly was, I think the government's contention here and also in their pleadings that the SPA is somehow the only route to reach folks like Mr. Tilley, Mr. Edwards, and Mr. Santos Martinez. I just want to say all three of those defendants at the time, now patients, were on the cusp of a Jackson finding. It's the same thing that happened with Mr. Santos Martinez. It's before Judge Lee, on the cusp of a Jackson finding. The government kind of reaches around that to pull them out of that world. To say that Mr. Edwards can only be civilly committed because he could argue at a civil commitment hearing under the CIDA that his intellectual disability doesn't cause, say, the dangerous behavior, would actually also preclude him from being committed under the SPA. I mean, the constitutional law has advanced greatly since 1948, and Kansas v. Hendricks is very clear. You commit a person based on the quote-unquote dangerousness of them being a sex offense recidivist risk, requires the finding that there's a mental abnormality or mental condition, and that there's a link between the two. The SPA has to be read in that same manner. There has to be an abnormality or condition, mental abnormality or condition, and a link to the dangerousness, and that's exactly what the CIDA also requires. So Mr. Edwards would essentially be in the same posture. The government's litigation would be in the same posture in either of those worlds. It just seems to make much more sense, frankly, for it to proceed through the CIDA via the Jackson hearing that we're requesting. And I think that's all. If there are no more questions, that would be it
Very
for me.
much. Okay.
Thank you, Your Honor.
Thank you to both sides for your briefs and your arguments today, and we will take the case under quick advisement. We are adjourned.
All right.